generally in Ohio, a business or landowner is not responsible for injuries that result from open and obvious dangers. And Ohio considers the natural accumulation of ice and snow an open and obvious danger. So if you are, generally speaking, if you're walking past a business and you slip and fall on a natural accumulation of ice and snow, you're not going to be able to recover. And what's a natural accumulation? It's snow that fell from, or ice that fell from the sky. So there's either snow squall or freezing rain, and if there's ice or snow there, then and you fall on that and it's a natural accumulation, you may not be able to recover for that personal injury that resulted from that slip and fall. So you can't get compensation, you might not be able to get lost wages. The property owner, business owner may not be responsible for that injury. And what's an unnatural accumulation? An unnatural accumulation of ice and snow might be like you have a leaky pipe, or the pipe bursts and there's water flooding over the sidewalk and that creates a sheet of ice. That would not be a natural accumulation of ice and snow, and therefore you may be able to recover in that instance. Likewise, if you're walking in an entrance and the awning in front of the entrance to the business is ripped up, it's damaged, and there's water dripping, and that water dripping in front of the business creates, again, ice, and you slip on that ice, then you may be able to recover. And this scenario played out up in Cleveland recently in an appeals case called Medeiros versus Applebee's. And what ended up happening is Medeiros was walking into Applebee's to pick up an order, and when she was walking in front of there, she ended up slipping on, I guess, a patch of ice and suffered a significant injury. And the court in that instance said it was an open and obvious danger because it was a natural accumulation of ice. There was no evidence that the ice was there due to an unnatural accumulation, i.e. the awning in front of Applebee's was perfectly functional, there was no damage, and there was no evidence it was dripping on that sidewalk on a periodic basis. So that person was, they're out of luck, and they're responsible for their own medical bills and lost wages. It's kind of a rough rule, and it's kind of you think that's not really fair, but that's generally how it is in Ohio. And bottom line is, you should still, if you fall, due to the ice or snow in front of a business, you still might contact an attorney, and frankly, maybe you should. Maybe you have a case, but in a lot of instances, if it's a natural accumulation, you're stuck, you're out of luck. So bottom line is, stay safe out there, look out for the ice and snow.